Welcome back, Love Nation. This is Nina. Make sure you guys like, share, and subscribe. Thank you to everybody that has been coming to my channel. Like this video, share this video, and hit that notification bell so you guys know when I drop my next one. We have a case update with Blake Lively and Justin B. And this is going over information that they want subpoenaed. And as you guys can see, this was sent via ECF, which is electronic, to the court. And we're going to get straight into this. This is probably going to be another turning point in this case, as we're going to actually wait for what the judge decides on what can be subpoenaed and what has not been, what needs to be left out of court. For those of you that don't follow court cases, this is actually normal to ask for as much information as possible before you start going to depositions and putting the case together, etc. And this is saying, Dear Judge Lehman, that might be Lyman, so excuse me if I didn't say that correctly. We write to address the Wayfarers Party letter to the court docket number 93 in connection with the court's February 19th, 2025 order, taking under advisement the Wayfarer Party's letter motion for discovery, docket number 85. That letter motion concerns purported objections to third-party subpoenas, the subpoena served by Blake Lively. On February 20th of 2025, the parties held a meet and confer, during which counsel were able to agree that removing any requests for locational data from the subpoenas and providing express language to clarify, as had previously been communicated to the Wayfarer parties, that the requests applied exclusively to non-content information. Keyword in bold, non-content information, would allow certain of the Wayfarer parties' concerns. Nevertheless, counsel for the Wayfarer parties continued to maintain that the subpoenas were overbroad. Counsel for Blake Lively expressly requested that the Wayfarer parties identify any modifications that would allow their concerns with the subpoenas punitive overbreadth, but the only limitation that the Wayfarer parties were able to identify was their demand that Blake Lively limit her request to contact specific with third-party telephone numbers identified in advance. I'm going to pause right there. In a nutshell, taking out some of this legal mumbo jumbo, it's basically said we would like to limit our scope to specifically parties directly involved in this, and not just trying to just download somebody's entire phone content. They basically are saying, okay, you're only going to get what is privy to what is directly filed in this case, and not, for example, somebody's private messages with their mother or their cousin, basically. Now, in the broad scope of this, if you want to look at everything flying back and forth, this actually could drag Taylor Swift into this, because I'm sure Blake Lively texted or called her at this time, and Taylor Swift is kind of indirectly involved in this situation. So yes, Taylor Swift might actually have her telephone text messages subpoenaed. Let's continue. As Blake Lively's counsel noted, such a limitation is inappropriate given the purpose of the specific discovery sought and the purpose of discovery generally. As this continues, the Wayfarer Party has fallen far short of that burden, making instead only general and conclusory objections as to the overbreadth of the subpoenas, initially going so far as to assert that no case law needed to be shared with counsel for Blake Lively or Reynolds parties on this issue. Courts in the circuit has consistently held that it is insufficient for movements to make only general and conclusory objections in the context of a motion to quash. See case files. Denying motion to quash where movement only provided conclusory objections that subpoenas were overbroad. Now, again, they're trying to limit the scope of who will reasonably be looked at. Not all the searches, just what is reasonably for this case. This continues. The Wayfarers Party most recent letter underscores their fundamental misunderstanding of the fact that discovery of carriers' records is not only permissible, but routine in federal litigation. I think it's actually more routine in a felony case, not a civil um, case. Nobody has been charged in a crime with this case. This is a civil case. In the words of their own cited authority, the only question before the court is whether the disclosure of the telephone records is reasonably calculated to lead to the discovery of admissible evidence. See Sovereign Partners Ltd. versus Rest Teams. And then it continues. Here the parties are at the outset of the discovery. Ms. Blake Lively seeks communications among the Wayfarer parties and specified other individuals who have already appeared on communications tying them to the performance of publicity, crisis, or digital services for Justin B. or Wayfarer. Such information is reasonably calculated to lead to the discovery of admissible evidence regarding communications not only among the defendants, but among the larger network of individuals who perpetrated the untraceable campaign against Blake Lively and as is Sovereign Partners. The requested records fit easily within this broad definition of relevance. The Wayfarers Party's baseline objection to the production of carrier records, that they reveal communications with others, failed to acknowledge that there are no privacy or privilege interests in such information. And they cited another court case ordering the production of numerical information including timesheets, billing reports, telephone logs concerning communications between defendants and their attorneys because none of the sought documents revealed the substance of any privileged communications. Citing Brayton versus Murphy, another court case. Telephone records, such as telephone numbers, is not an invasion of privacy. An individual does not have a legitimate expectation of privacy in the telephone numbers that are dialed on his phone. The Wayfarer parties have not identified legal authority standing for the proposition that subpoena to communications carriers must or even should be limited, as they propose. To the contrary, courts regularly permit such discovery. And again, I think that is more permitted with felony cases or cases that could lead to something being a felony. I think. I could be wrong. Also, when they're talking a broad scope, yes, it should be, say, limited to, give an example, maybe the PR team, that could be in the scope of this. Say he was discussing this case or discussing Blake Lively to a YouTuber at the time. Okay, let's just put that out there. Say he was discussing this with a YouTuber, and he was like, "Oh, I'll pay you $1,000 if you start to put this information out." That could be privy to this case. On the other hand, Justin could say the same thing about her in his lawsuit. He could be like, "Well, you were using Taylor Swift to, take over the meeting. I need all of Taylor Swift messages." So this is definitely going to be a juicy back and forth, and I'm waiting to see what the judge will say. And the last paragraph basically says the same thing. In the interest of resolving the parties' dispute, notwithstanding the appropriateness of the initial subpoenas last week, Blake Lively provided through counsel notices of intent to serve modified subpoenas to AT&T, Verizon, and T-Mobile. The modified subpoenas remove the request for locational data, further tailor the applicable time periods, and specify on their face that they seek only basic subscriber information, that is call logs and text logs reflecting non-content numerical information regarding ingoing and outgoing calls or text messages related to identified telephone numbers over specific time periods. Notwithstanding defendants' continued objections to those modified subpoenas, Blake Lively stands ready to issue them pending resolution to the present motion of this court. Those modified subpoenas, like the initial subpoena, are reasonably calculated to lead to the discovery of admissible evidence regarding such matters of as a pattern of communications among Wayfarer and unknown associates during Blake Lively's alleged harassment, as well as the inception, duration, and the scope of the untraceable retaliatory campaign against her that followed. Signed, Michael Gottlieb of his court, of that law office, and this is his phone number, email, and address. I think that the judge will actually grant this. This is really not anything too crazy that they're asking for, as long as they're limiting the scope and being specific with this if it actually has to do with the case. And again, I think Justin's team can actually come right back around and ask for the same thing, as long as what they're looking for is specific to her trying to prove the case. So again, this is going to be interesting, and there's really nothing crazy asked in this filing. I think this is actually normal. So tell me what you guys think below. Like, share, subscribe. Till next time, this is your update. Share your opinion below. Bye, guys.